Welcome to Opinion Journal. I'm Mary Kissel. A federal judge ruled that the National Security Agency's phone surveillance program is unconstitutional. Why, and will his ruling stand? I've got UC Berkeley law professor John Yoo joining me now from the left coast. John, I thought there was a Supreme Court precedent here.
There is. It's called Smith versus Maryland, and I have to say Judge Leon did all kinds of somersaults to get around it. Smith versus Maryland said that we don't have any privacy interests in phone numbers that we dial because it's information that we give to third parties, i.e. the telephone companies. So we can't make a claim to keep those private when we've already given them up to companies.
So is he essentially ignoring the Supreme Court precedent because somehow technology has moved on and that's an excuse to just ignore that ruling?
Exactly. And he pretty much says as much. He says, I think Smith versus Maryland was decided by the Supreme Court, but because we use our phones so much, and I think more importantly, I think this is where he really has trouble in trying to get around Smith versus Maryland. He says it's not really the information over which we suddenly have privacy, it's that we have much stronger technologies to collect it and analyze it. But why aren't all of our credit card records and our travel reservations and even how we spend money, why isn't that all no longer, I'm sorry, why is that all not private now? But we're quite accustomed to to companies and government being able to analyze and sort through all of that information without us thinking it has some kind of Fourth Amendment constitutional protection.
Well, that's just it. That's why this ruling seems so odd to me. I mean, don't we have less expectation of privacy in today's global interlinked world than we did back in the 70s?
Yeah, and I quite agree with you, Mary, and I also think that's a big problem with the bigger issue here, which is that why is one federal judge taking it upon himself? Conservative as this individual judge is, and I have to say, I've known Judge Leon since before he went on the bench, and I consider him a friend. But why would one single judge be the person who's going to decide for everyone what our privacy interests are, especially judges? I mean, I don't know about Judge Leon, but I don't think most judges are out there using Facebook and LinkedIn.
Now, you know this judge personally. Is this representative of his record? I mean, isn't this the same guy that upheld McCain-Feingold?
And also, he's been very tough on national security. He's been very reluctant to, in fact, he's never, as far as I know, let out any of the prisoners from Guantanamo Bay, even though he's had a lot of those cases. So this is not one of those cases where you can say, oh, this is like the judge up in New York City who tried to ban stop and frisk and was openly sympathetic to the ACLU. I think, in fact, Judge Leon here is trying to figure out where the Supreme Court might be going in the future, although I think in this case, that's not his job. If the Supreme Court wants to overrule Smith versus Maryland and it wants to expand privacy rights over these kinds of telephone calls, that's the Supreme Court's job, not a district court judge.
Well, let's hope that this one goes up to the Supreme Court so we can get some clarity. UC Berkeley law professor John Yoo, thank you so much for joining us.